this is Jamie Austin, and welcome back again to Real Estate of Mind, where we try to keep things real simple, real answers for real questions for you, our listeners, and our audience. So welcome back. This is podcast number 5, and we would also like to give a really big shout out to our fantastic sponsor, Pest Service Direct. For all your pest and termite needs, all you have to do for them is call 1-888-909-4PSD or download the app on iTunes or Google Play. Thank you again. All right, so today we have a fantastic guest. Greg Koffman is here. He's a real estate attorney. I'm going to throw it to him in just a couple of seconds to introduce himself and to tell you why he's here. What I did find out is a lot of people are like, why would you hire a real estate attorney, and at what point would you need one? Very good questions. And most of the time, if you need an attorney involved, usually something hasn't gone quite right. But that's why, as a real estate broker, I never give real estate advice that an attorney would give. I always say, if it's out of my wheelhouse, I direct it to a really great real estate attorney, and Greg Koffman is just that. So, Greg, welcome to the show.
Well, thank you, Jamie. It's a pleasure to be here.
So tell me, what's the law firm you work for?
Our firm is Rosenberg and Kaufman. We're located in Westwood, California.
Fantastic. And so I had a lot of questions I was kind of feeling out some buyer questions before we have callers. What is the type of cases that you see on your desk most frequently?
Well, in our office, we handle both purchase and sale transactions as well as lease transactions.
Okay.
So on the purchase and sale side, we'll often be asked to review purchase and sale agreements, escrow instructions, title reports, title issues, things that would come up during the purchase and sale transaction. On the lease side, we're typically asked to review leases. Mm-hmm. Oftentimes we negotiate and draft leases. It just depends on which side of the transaction our client is on. But those are the typical arrangements that we'll get involved with.
So basically just to make sure that the contracts are all in good standing and all the language makes sense and everybody's clear on both sides as to what you're actually agreeing to in the purchase.
Correct? Yeah, we focus on the legal issues. We don't get involved in comps and
price
values
and
price
stuff.
and all that
Yeah.
stuff. We leave that to you brokers.
Very cool. So I was thinking for a real estate attorney, because there's a lot of states, and this is actually a nationwide show, so a lot of states don't use escrow companies to complete their transactions. They use real estate attorneys, like especially in New York City. Escrow companies are sort of not as used prevalently as is real estate attorneys, and real estate attorneys are at the table when you close the deal, correct?
That's correct. We're lucky here in California. We use escrow companies. They deal with all that stuff, the exchange of the monies, the canceling of old liens, putting the new liens on with title companies. We don't have to get involved in any of that.
That's nice. All right. So and when do you find that potentially, because when you start a transaction, there is an agreement of price, and then there's an earnest money that's put down to reserve the property, and then you open escrow. I had some questions about at what point would a buyer risk losing their earnest money deposit, or at what point have you seen that situation gone to the south where there was not an agreement that could be reached between the buyer and seller, and then they call you?
Well, you mentioned this earlier before I was going to comment. The time to call an attorney is not when you have a legal problem. The time is to have the contracts reviewed, bring the attorney in early to prevent that legal problem.
Exactly.
So that's always my recommendation and advice. In this case, your question is, when is the buyer at risk of losing their deposit? Most of the contracts are pretty good about giving the buyer an inspection period. There's a contingency period where they can take a look-see at the property, and if they decide to get out during that contingency period, they can usually get out and get all their money back.
Exactly.
And walk away from the transaction. The problem becomes when the contingency period has expired, mm-hmm. or buyer has waived their contingencies for whatever reason, and then they change their mind. Once it's a done deal,
right?
And then they want to get out of the transaction. They get a little buyer's remorse. Maybe they think they're overpaying. Maybe they found another piece of property they like. Whatever mm-hmm. reason, that's when the sellers start saying, "Wait a minute, we're keeping the deposit."
Got it.
So it just depends on whether it falls within the contingency period or after the contingency period's expired.
And a couple of times I've run into this situation where I've had other real estate agents in my office run into this, where everything was going hunky-dory down the path of closing and everything was great. Inspections were done. Everybody had, done their due diligence on the property. They removed all contingencies. And then they find out that the seller maybe didn't disclose something about the house. So, and they didn't sign the arbitration or mediation clause. So then, therefore, at that point is where I would say, okay, everything was looking great up until this point. Now we got to call in some different forces, because at this point, there's got to be some agreement between the buyer and the seller. And as the real estate agent, I can't really do that for them. I mean, I can guide them. And what I would guide them to do is ask an advice of an attorney, a real estate attorney that's good and can help guide them through that process. Has that ever happened to you?
No, absolutely. It happens on a regular basis. Typically, if the buyer finds out about a condition before escrow has closed, you can usually use that to leverage your way out of the deal.
Yeah.
And if you go for if you find out about the condition and you go forward and buy the property, then you've bought the property knowing that condition exists, and your remedies are not as strong.
Right.
So if you find out before escrow is closed, you can usually get out of the deal. If you find out after escrow has closed,
right,
that's when it becomes a little bit more problematic. Now you have to take a look at, what wasn't disclosed. Did the buyer know about it? Because in California, the obligation is to disclose what you know.
Right, exactly.
If it's something the seller didn't even know, then maybe they didn't have an obligation to disclose it, even though the condition may have existed. So you have to prove, A, that the seller knew about it,
right,
and then didn't disclose it to you. But if it's something that's open and obvious that you could have discovered, during a normal inspection, for example, or a review of some kind of public record, then you may be held to have looked at it,
right,
even though you may not have looked at it.
Because when you do normal inspections, it's not like you're ripping open walls. So you really, that's why they call it a visual inspection, right?
Correct.
So there's amount of due diligence that an agent can do and the buyer can do, and even when the buyer hires inspectors. They're not going to be ripping open walls to go, oh, there was maybe a leak 20 years ago. So there is that situation, and I had that happen to me. My seller did disclose a leak in the ceiling. He had the home warranty company come fix the leak, and it was something that was minor, but because the pressure wasn't that large, it was kind of one of the slow burning things. But they came in, fixed it, resealed the ceiling, no problem. So we absolutely disclosed that. He said he had never had any more leaks past that. But then when the buyer got in there and started really basically remodeling and moving things, they went, oh, there's black mold. It went way, 20 feet into the property and all that stuff. And I was like, we disclosed everything up front, everything that my seller actually knew. And so they were about to go down the path of, hiring a real estate attorney to sue my seller. But I was like, wait a minute, let's go back to the contracts, right? Go back to the contracts. I disclosed everything in my agent visual inspection, and he disclosed it in his seller disclosures. So we felt pretty confident that we were protected because he hasn't ripped open the wall since. But what are some situations that you've run across where maybe like that has happened?
I've certainly run into the situation you've described where the seller didn't know what was inside the wall. I've also had situations where there was a leak, and it was pretty clear that the seller had literally painted and repaired the wall, painted the wall, never repaired the leak behind it.
There you go. And
then the buyer discovers it later. And
that's a tough thing because you have to prove negligence. And is that a tough thing for a real estate attorney to kind of prove that's a seller? They were like, oh, I just put a fresh coat of paint on, and then you're like, but there was a deeper problem you let go unchecked.
Well, and they painted over.
Right.
It's like there was a stain on the ceiling, and they just slapped a coat of paint on it.
Yep.
And that's always a problem. And it becomes a question of proving what the seller knew. Maybe
exactly.
You can talk to the contractor that did the work, what was disclosed to them. Oftentimes, you want to look at the buyer's inspection reports. So some of those inspectors are pretty good and have a pretty good eye and can identify things. And I had a situation once where the buyer's inspector identified a problem with the foundation, and the buyer bought the property anyway, and then later came back and complained that there was a foundation problem. And we were able to go back and look at their own inspector's report.
Right.
It wasn't something that we as the seller disclosed because we didn't know about it.
Right.
But their inspector had identified
Came up with it.
And so again, it was something that that their client bought the property knowing the problem existed. So my seller got out scot-free.
And really hard to do. And so just for listeners and viewers out there, As a real estate broker for many, many years, my advice to you if you're selling a property is disclose, disclose, disclose. Just as soon as you think, oh, that little thing, if I don't tell them that I've got a pit bull next door or there's a noise nuisance of airplanes, well, it's now white noise to me, so I don't ever hear it, right? I've had a lot of people, try to use that one. I'm like, no, disclose everything. Because I feel like if something's going to really scare somebody off from buying a property, better know about it at the beginning so nobody's time is wasted, right?
Yeah, right. One huge issue, a lot of work used to be done without permits.
Right.
And, and even on the transfer disclosure statement form, it's asking you, did you do any work without permits? And it's amazing how much work requires a permit and people don't pull it.
Yep.
And so you're always better off disclosing, yes, I did this without a permit. And the more, like you say, the more you disclose, the better off you are as the seller. Let the buyer know what's going on. They can make an informed decision whether they want to buy the house or not.
Right. And speaking of even permits, it's kind of interesting. In LA, there's a lot of, but he's licensed. He was a licensed contractor, and he did all the work. And
it was done to code.
It was done to code, so you think. And then all of a sudden, you really go downtown to file the permit, and it's like, no, it's not. And the codes change all the time. So then if you're going to get in trouble like that, but I've even had my buyer was buying a house in the Valley. They had turned a pool house into a guest house, not permitted, but if they had have permitted, it would have added like another 500 square feet, so therefore they would have had to pay more taxes. So what they did is they filed permits up to the point where you record them so that they could show the people that they did file permits, but they just never recorded them. So the seller was taking advantage of the smaller square footage and then turning it over basically to the buyer. But my buyer's attorneys, because he had attorneys in New York that were looking over everything, when we got the appraisal done, they're like, whoa, this is way lower than we were expecting. And I was like, yes, because of the juxtaposition of the square footage and the permits and what the work was done on the house. So we actually got them to go back and do a reappraisal, and then I went down with the listing agent, which was really great that we worked so well together, and we pulled all the permits so that at least my buyer could feel comfortable that the work was done properly. They just didn't file. So now it's up to you, if you buy this property, to go file them yourself and get it all squared away with the city so that everything's legit. But that could technically be something where a real estate attorney would have to come in and kind of like, okay, there's a discrepancy of 1,000 square feet. So that makes a big difference. So we would need you to step in and kind of help us with that. So let's see what happens. We actually already discussed it. This is happening so naturally. I was like, I have my questions and yet we're already coming. If you own an income property and want to evict tenants, would you hire a real estate attorney? What is your best advice on that?
My advice, whether it's income property or just regular, whatever it is, if you've got a tenant and you want to evict them,
yep,
my recommendation is always to hire an attorney that understands the eviction process.
Absolutely.
It's very technical. The notices that you have to give the tenant have to say certain things.
Yep.
If you don't do it right, the court will throw your case out.
That's
You got to
right.
start all over. It'll cost you, months and months and months of aggravation, which will cost you months and months and months of lost rent.
Yep.
I highly recommend hiring an attorney to handle the eviction process from start to finish.
And because eviction now in California is becoming a really, really hot button because we've got new rent control laws that are coming into place. And so it's going to be even harder to get tenants out of the property. So
correct.
I am telling you, because I just sold an income property for that very reason. And I said to them, look, this, and it was, quote, a best case scenario tenant. Everything was great between my seller and the tenant. They knew they were going to have to get out. We gave them the notice, and I said, this is about as far as I can go to tell you what we need to do. And I'm going to tell you that is, even in the best case scenario, get a real estate attorney involved so that you make sure you're handling everything right. Because at a certain point, I kind of have to step out and make sure the seller does things right to handle the tenant properly. And you're right, it is a tricky minefield to navigate. And if you're not a pro at it, most of the time, if you're selling a property, it's about the days to market. You want to get onto market and sell it. And if you don't do it right, you're right. The court could throw it out and then the clock starts all over again and you've wasted 4 months instead of a potential 2 or 1 or whatever the case may be.
That's correct.
Yep. So have you run into any really difficult eviction cases?
Yeah. The one that comes to mind is we represented a gentleman who had a home, moved out to another part of the state, and rented out his home to this woman, and life was good. Her financial situation was fine. She stopped paying rent, and we served her with a 3-day notice to pay. She didn't pay. We went through the eviction process. She played every game in the book. She did every trick she could play to stall and as long as possible. And then we finally went to trial. We got our judgment. And the way that the process works here in California is
Please explain.
You get your judgment. You give that to get a writ of possession. You give it to the sheriff. The sheriff goes out and posts a notice on the door saying, please move out in 5 days or we're coming back to physically remove you from the property.
Yeah.
And by then, usually tenants have gotten the idea that their
they're not going to win and their
time is up and they should leave.
Right.
In this particular case, this woman not only stayed, she barricaded the door.
Wow.
And so we literally had to have it's the sheriffs trying to bust down the door, break into the house, to literally physically remove her and her daughter from the property.
Wow.
It was it was sad.
Yeah.
But they typically won't go that far.
Right.
But she put up a fight the entire way.
And it was definitely just a rental from the beginning. She never had any rights to it or anything like that.
That's correct. Yeah. No. When she stopped paying, we go through the whole process. The judge determined she had no rights, and
let me ask you
leave.
this, because there's an interesting, and this is coming up more and more. So, like, I own a property, right? Or let's say I'm renting a property. My name singly is on the lease. I invite my son to come and live with me. He's not on the lease. And he's proving a problem for the sellers to actually sell the property, because now there's this adult in there that's now taking over the garage, fixing cars. Like, people are like, oh, that certainly has changed. This was a well-maintained property. Now it doesn't look like it's as well-maintained because of this gentleman that was not on the lease. What are the ramifications of not putting somebody on the lease if they move in with you?
It's a complicated question because it's going to be first we're going to look at the actual terms of the lease. And some leases are very strict about nobody else can occupy the property without the landlord's consent, and there's all these rules and restrictions. Then you have to look at the jurisdiction that you're in to find out if there's rent control that applies.
Right.
Because under rent control, even though they may not be on the lease, they still could become a tenant covered by the rent control, which would then make it more difficult to
get them out. Absolutely.
And so you want to take a look at whether or not they've really become a tenant. How long were they there? Did you accept rent knowing that they were there? Did you accept rent from them in particular, or did the rent still come from
just the
person you knew that was the tenant?
Right.
So you have to kind of look at the facts of that to kind of determine
I actually had
where you are.
A situation with a friend of mine. She was working in the studios, whatever. She worked all the time, and then she traveled a lot. So she said, well, I'm going to have a roommate. The roommate came in, and the roommate situation did not work out very quickly. And then she realized her name was just on the lease. She didn't have him on the lease. But because it was rent controlled, he basically squatted in the apartment, and she had to leave. And so that was that situation. And you're like, how could that even get to that point? But you're right. There's a lot of factors that get involved. Again, hire a real estate attorney. So you don't have to navigate that system by yourself. We do have, you can call the Rent Stabilization Board in LA, and you can find out a lot of situations.
And they can be very helpful.
They can be very helpful. They can tell you exactly. There's another website called Zemus that you can look on, and it can tell you whether a property falls within rent control and what the stipulations are a little bit. But then the Rent Stabilization Board is a really great way to go if you want to pick up the phone and go, because if you're going to try to sell the place and everything else is fine and everybody knows they're going to leave, but you have to pay relocation fees, they vary. They vary, if somebody's elderly, they vary if somebody's handicapped, they vary age-wise, they vary if they have kids. And all of that stuff is stuff you want to take into consideration when you're selling or purchasing a property.
Correct.
Yeah.
Now, in the situation that you described, they may, if they're there, doing car repairs on the property, and those may be separate violations of the lease, and may give rise to reasons that you could evict them,
right?
Or if they're creating a nuisance to other tenants on the property, assuming it's an apartment building.
Yeah.
So you want to look at, are they a tenant, are they not, and that's one issue, but also you want to look at their activity that they're conducting on the property to find out if you can use some of that activity as a basis to evict them.
Or like illegal substances or something.
Illegal substances?
Absolutely. Yep. And we've actually had, it's really sad. There's been an rise in homelessness across the nation. but Los Angeles and San Francisco, some of the larger cities, have really been hit particularly hard. Are you seeing any cases where properties are like that people are wanting to fight back or try to instill any legislation or laws or anything about that? Is that anywhere coming across your desk?
Nothing that's come across our desk related to homelessness.
Okay. Yeah, that's something like the city's kind of trying to take care of. But I know that in some areas they're afraid that it's going to affect property values, and it may, and who knows, but it's a really sad state. Do we, you know what, let's, I think we have a caller, so why don't we take a caller and see who we have?
Oh,
and then we'll see if you can answer another question or two.
Perfect.
Hi, this is Jamie Austin with Real Estate of Mind. Who do we have here? Hello? Hi, this is Jamie. Who we have? Now I hear you. Who do we have here?
Hi, this is Lauren.
Hi, Lauren. How are you?
Good. How are you?
Good. Where are you calling from, Lauren?
I am calling from the Marina del Rey, California.
I love it. What can we answer for you, lovely Lauren?
So I was calling to see, at what point, my family and I, we own a couple properties, and we have some difficult tenants. And I was just wondering, at what point do we bring in kind of legal counsel or seek outside services with some of our difficult tenants?
That's a really great question, and I think I'm going to throw it to Greg, absolutely. But even at the beginning of the show, he said the time to bring in a real estate attorney is not when the problem gets really exacerbated, but beforehand, so you can strategize. So, Greg, would you like to take that call?
Well, no, hi, Lauren. It's a pleasure to meet you.
Hey, Greg.
Yeah. Jamie hit the nail on the head. The time to bring in the lawyer is when you're taking in that tenant and creating the lease so that the lease provides you with the greatest amount of protection. Obviously, once if you're inheriting a situation where the lease already exists, it begins with looking at, what is the tenant doing to be a problem? What does the lease say about those issues? And sometimes a nice strong demand letter is a shot across the bow and can get the tenant to behave.
Okay.
Other times you've got to find a violation and you serve them with a 3-day notice to perform or a 30-day notice, depending on what the factors are. But the time to reach out to a lawyer is either when you're taking that tenant in or as soon as the problem exists.
Now, I have a question for you, Lauren. Is your family thinking about selling, or are they thinking about just trying to vacate the problem tenant and move in a better tenant?
To really vacate the problem tenant,
Okay.
We've tried to mediate and settle it and have discussions, but it just continues to escalate. So it seems like it is time to potentially figure out if there is a hardcore violation of what's written into their agreement.
That's great. So that was Greg's. Take a look at the lease and see what that is. So tell me this, Greg, I just thinking this off the top of my head, is it also a good idea to maybe record like written things like on this day, they were like doing something, so you kind of keep a record? Not that you're, going to be over at the property all the time, but if you know that they've called you and there's something that you could keep recording so that if there's a time, if a judge or anybody asks, you can say at this time they did this like 7 or 8 times or something like that. Is that helpful?
Oh, yeah, you certainly want to keep a detailed note so that you can refer back and remember exactly what they did on what date and make that record. Okay. You also want to create a paper trail, whether it's by I don't know how you communicate with these tenants, whether it's by letter, by email, however. You want to communicate with them in writing. That you can, you've definitely communicated the problem to them. They're on notice that it's a problem. You've given them an opportunity to correct it. You've done everything that you can reasonably to deal with the situation before you get it in court. Because the judge wants to see that people are acting reasonable, and there's no better way to do that than with a good paper trail.
There you go. All right. So that was good. Does that answer your question?
It certainly does. And then when we're ready to go, how do we go about finding a real estate attorney to liaise with?
Well, Greg at the end of the show is going to give his information. So if you tune in or stay tuned in, I promise you will have his information and email, and you can give him a call. And he's also a local attorney in Westwood.
Okay. Oh, fantastic. Okay. I like local.
I do too. All right, Lauren, thanks so much for calling. Really appreciate it.
All right. Thank you.
You bet. Thank you. Take care. So that was a good question. Yeah. It was like, and we have another caller. So like, it's just like that. Like that was a great way, and we were able to help her out a little bit. So
Perfect.
yeah, so hang on. Yes, let's take another caller. Hi, this is Jamie with Real
Hi.
Estate of Mine. Hi, who is this?
Hi, hi, Jamie. My name's Casey.
Hi, Casey. How are you?
Good. How are you?
Good. What can I help you with? We're here with Greg Koffman, a real estate attorney. What question do you have for Greg?
Hi, Greg. So I'm actually looking to buy my first house, and honestly, I don't have any clue what I'm getting into. And as a first-time home buyer, I'm just wondering, like, should I hire an attorney, or can I just trust my realtor? Like, I have no idea what to do.
That's a really good question. And actually, I would say on the offset, I would say interview agents that are very competent, hopefully, and then you choose one. And normally a really good broker can guide you through that process pretty well without having a real estate attorney. However, if you ever feel at any time there's any uncomfortableness with the contracts and you maybe felt like your realtor didn't explain it well to you, then it never hurts to have a real estate attorney look over it and just make sure your best interests are at heart. I mean, I'm a real stickler for contracts because I am a broker. So I'm a real stickler for explaining the contracts, but I find that in this information age where everybody's now like docu-signing contracts, they're taking less time to actually explain them verbatim. So it's very important to me, for my clients at least, that I explain the contract, and then after they really understand what it is they're signing, then I don't mind, signing electronically. I don't have a problem with that at all. But I do think it's incredibly important that first time you do understand exactly what it is you're signing. Greg, do you have anything to add to that?
No, I think Jamie's advice is spot on. The only other thing I might add would be to consult with a good loan broker.
Absolutely.
Because until you know what you can afford and what your financial obligations are going to be, you're not good. The broker or the agent doesn't even know what properties to show you, what price range you're in. So
that's very good advice. And actually, even when we would meet for a buyer consultation, I would have you come in and I would recommend a mortgage broker right away. Because until you have those pieces of the puzzle together, you trust them to get the financial part of the picture together for you. And then you trust, hopefully, a really strong broker to then take that information and find you the property and guide you through the process of buying your first home. And then again, like I said, if there's anything that you feel like is not taken care of very well, then it never hurts to hire a real estate attorney to have them to look over everything, even title reports, because you said it's not just about contracts. Like a real estate attorney can even look over a title report, because even title reports can be pretty verbose and a little intimidating if you don't know what you're looking at. So having a real estate attorney in your back pocket is, it's never a bad thing to have more experts and more expertise helping you get through the process than less, I will say.
perfect.
Sure, that makes sense. Okay.
Well, does that answer your
appreciate
question?
that.
You bet. No worries.
Yeah,
Thank you for calling in. I so appreciate it. Thank you for taking the time. And if you think
Thank
of
you.
anything else, give us a call back.
Thank you.
You bet. Bye-bye. So those were great calls. And I think the one thing that we were kind of leading into like a little bit before then was like, in your opinion, is arbitration and mediation the best route to go, or would you consider just outright just hiring a real estate attorney first?
Well, I look at those two topics as being different. First of all,
Okay.
Even if you're going into mediation and arbitration, I would recommend having a real estate attorney with you through
Yep.
that process.
Okay.
Because the attorney can help present the legal arguments during the mediation that may help get your matter resolved.
Right.
And in arbitration, you certainly would want representation so that your position is put
Clear.
forward in the best way possible. So the real estate attorney for sure. The question, if in my mind, is do you then go with arbitration or do you want to litigate the case?
Right.
Sorry.
Quite all right.
Yeah. Now, typically, at least in California, the standard forms require mediation even if you don't pick arbitration.
Right.
So you're going to be going to mediation.
They're going to start there.
They're going to start there anyway. Arbitration, if you're depending on the circumstances.
Can you explain the difference? I don't mean to interrupt.
No,
I want the listeners and the viewers to understand the difference between arbitration and mediation, because that could be a big one.
Correct. In arbitration, you're hiring an arbitrator, sometimes a judge, sometimes a lawyer, sometimes, some other profession, but you're hiring somebody to hear your case. It's private. It's much faster. You it's less formal. Typically, will take a shorter amount of time to get through. But the decision of that person is binding. You
don't have any recourse after that, whatever that arbitrator decides.
Yeah, it's done. It can be enforced by a court.
That's a good.
But the decision is final, which is good or bad.
Or bad, depending on what arbitrator you get that day.
Correct. Now, and it's also confidential. There's no public record of arbitrations.
Okay.
If you go to litigation, it's a longer process. Mm-hmm. It's more involved. It's probably going to be more expensive. But there are rules of evidence that the judge is required to follow. If they don't, you can go up on appeal. From there you can appeal to the Supreme Court if you want to. So they're different processes. So if you're looking for something that's less expensive,
down and dirty and fast.
Yep. Arbitration is definitely the way to go.
Got it.
If you want something that's if you don't mind it being a little bit more prolonged.
But thorough
more expensive,
and recorded,
and more thorough and recorded, and a public record of it.
Yeah.
Then litigation is what you're going to want.
And then But I think it's interesting because I think some people wouldn't have thought that you could have a real estate attorney present for both of those, and in which case, because there is a lot of legalese that even an arbitrator can throw at you that if you don't have representation, you might not understand the ramifications of the legalese, right?
Correct.
Okay. That's what I would have thought. Do you think handling a sale? So we have there are definitely situations where sellers want to sell their home on their own with no broker representation whatsoever. What is your feeling on that? Do you think that that's a good idea?
I actually don't, because there are very few people that are really, in a position to handle the transaction on their own.
Right.
And brokers serve, in my opinion, such an important function in that process.
I love you, Greg.
well, they do.
It's true. But
establishing values. If you're the seller, how do you know what your house is worth on the market if nobody's promoting your property and
that's right.
And exposing it to what the market.
Usually the argument is, which I do understand sellers, the argument is I'm going to save on commission. Here's the thing though, it's the statistics are done. Like a real estate broker will get you they'll get you more money than what you're thinking you're going to save on commission, even more because they know how to expose it to the open market and let the numbers play out. And usually that's the case. And if you're doing it as a for sale by owner, you don't usually market. You don't really expose the property to as much people or potential buyers. So therefore, you really take money off the table at the very get-go, even though the mindset is, I don't want to pay the commission. So, and there's a lot of, discount brokers, I'll do it for 2% or, whatever. And the truth of the matter is you get kind of what you pay for. So there is a real method to the madness as to why we do what we do and how we market things. So that's good. I was just wondering that because, it's depending on the market, like when it's a bullish market and the sellers are getting anything they want for their property, they're like, no problem, I can just sell it on my own. They still leave money on the table. And now that the market has shifted and now we're in a buyer's market, you're going to start to see, maybe I do want to hire a real estate professional because I don't want to leave any money on the table at this point. So I want somebody to guide me through that process.
Yeah, and that's on the seller side. On the buyer side, and oftentimes, buyers don't typically think about paying, the broker because it's usually the
seller
paying
usually
the
pays
commission.
for the commission in California.
So, for having a broker for the buyer, that broker is going to make sure that they get value for the dollar. And so I definitely recommend buyers for sure should have brokers, but sellers definitely.
And just in the state of California, so this is where I'm licensed. I'm not trying to say anything about any other state, but there were, I think up until the 70s, the state of California, it was a buyer beware. They didn't have agents that even represented buyers. So it was like, if the seller didn't disclose something, it was up to the buyer to do all their due diligence, make their own decisions whether they wanted to move forward with no representation whatsoever. So for those of you who are listening out there, hear me this, because as a broker, dual representation, which is where you represent both sides, is the most difficult thing to do. I understand where double-ending things to agents is very appealing because you get double the commission. However, in my 17-year career, I think I've double-ended maybe 5 deals. And that is only with implicit okay from the seller and where I thought I could do a really good job. For the most part, I always feel like a buyer needs their own representation. But when things were just crazy and flowing off, people were writing offers on the top of their cars and whatever else, it was usually because the listing agent said, write with me and I'll get you a better deal. Well, the truth of the matter is their fiduciary responsibility is to their seller. They didn't really get you a better deal. They got their seller a better deal. And then when it comes to having inspections, who do you think that agent is still going to side with probably more if they found out something in their due diligence? It's just not really equal. Do you have any cases where there was dual representation and then somebody came in and said, I just totally got screwed?
Oh, I mean, as a lawyer, that's what you're looking for, because anytime a broker represents both sides of the transaction,
yep,
you have conflicts of interest everywhere.
Absolutely.
And
can you say that one more time, please?
I said, anytime you have a broker that represents both sides, you can't represent both sides equally.
Yeah.
And so there are decisions you've got to make, and you're going to favor one side or another.
Yeah.
And there's conflicts of interest.
There are some states that don't even allow it. That much I know.
I'm not sure why we allow it.
Yeah.
Frankly, as lawyers, we can't represent both sides in a transaction. Of course.
And that makes total sense.
Yeah. So as a lawyer, legally, when I see that, I know that there's some vulnerability somewhere. I'm going to find it. I just have to look.
I have to look for it. Yep,
as soon
absolutely.
as I look for it, I'm going to find it.
Yep. Nope. And I totally agree. And that was kind of the one thing that I ran across in my office was that, the calls that I got from people very discontented were dual representation deals where the buyer was like, so they told me I couldn't get the property unless I wrote with the listing agent, which they should never do that. That's called strong-arming a buyer. And then once I got into the deal in escrow, I can never hear from the listing agent ever again. They won't. They don't call me back. The service isn't there. I mean, it's a list. It's a litany of lists of things I would have to deal with. And then I was just like, yeah, I get it. It's a business model for some, not for me, but I get why people do it. But you have to be so careful. And in which case, then I would definitely recommend a real estate attorney on that one to make sure that you're protected and covered. Yeah, absolutely. What is adverse possession, and what do you think about it?
Well, adverse possession is the rules for it vary state by state, but it's basically where one person acquires title to a piece of property that is really owned by somebody else through, using that piece of property, for a particular period of time. Here in California, you have to have title to the property or have access to the property, possess it in a manner that they say is open and hostile to the actual owner. You have to pay taxes on it. You have to possess it for 5 years, and so there's a whole bunch of requirements. Typically, it happens under some form of color of title where you think you own it. Maybe a boundary wall is not on the property line, and it's actually over on your neighbor's property. So you think it's yours because it's part of your backyard. Right. But until a survey comes and tells you where exactly the line is, you realize, oh, I guess that's not my property.
It's not mine.
And it's really difficult to prove because most often the property taxes are determined by the actual
square footage, by the boundaries, the meets and the bounds.
The meets and bounds of the property.
Mm-hmm.
And so usually you're not paying taxes on the property that you are possessing. So it's a very difficult.
So even a
concept
sliver
to
of
prove.
it would knock you out of getting the adverse possession.
Yeah, you wouldn't get adverse possession. Now you may have what we call an easement, which you can acquire through many of the same requirements that you possess it. It's open and hostile to the neighbor. It's obvious that they can see that you're using it. Those sorts of things. But with an easement, you're not required to pay the taxes on it.
Got it.
Now, you don't own title to it, but you may have exclusive use of it.
Right.
And,
this would be an example where, like a driveway, maybe you have a shared driveway. So you have an easement, but you have a property that you have to use the driveway to get to the back property, and maybe there's one a little bit up front. Yeah.
Correct.
Yeah, so that's just interesting. Do you see a lot of that happening? Like more rural areas, I would think, but I don't know. Tell me.
No. Well, you see it a lot, especially in hillside properties, where oftentimes the geography doesn't allow people to put walls on the actual boundary line. So they sort of put the wall where it's easiest to build, given the configurations of the lots.
Right.
And so you see it a lot there. We don't see a lot of adverse possession because of the tax requirement.
Right.
We do see easements where somebody has put a boundary line, a boundary wall in the wrong place, and
Yep.
it's now been incorporated into their backyard. And
Now, is that something where, like a title report? Because normally, like when you order a title report, they're supposed to look at all that, everywhere from delinquent taxes to like property lines and all that good stuff. To you get a little map and all that good stuff. Is that something then where you take the title report? Or is that something a little bit different?
it's actually a little bit different, and I don't want
Okay.
to get too deep into the weeds.
Sure.
There are different forms of title reports.
Mm-hmm.
There's a CLTA policy and an ALTA policy. One may come with a survey, one may not. But the title report doesn't really, although it will describe where the property is, it doesn't come out and actually put stakes in the ground
Right.
to say, okay, here's where this description is,
Right.
and
really mark it out.
Here's where this line is actually on this property.
Right.
What you really need is a survey.
Yep.
And a surveyor will come out
Yep.
and they will tell you exactly, where that line is on your particular piece of property.
I had that happen on a property that I sold years ago. The seller was like, "Oh no, this is my wall," and I was like, I don't know about that," because there was something I was looking at visually, and I thought it looked like that wall had been moved. So I said, just to be on the safe side, we should do a survey. And sure enough, the wall was like 2 feet off into the neighbor's property. So that's quite a bit, and it was like 20 feet long. So I was like, that's going to come up, and that could be a real problem that they could, like stop the sale, and they'd have every right to until that was adjusted and fixed.
Yeah, no, and it can be a huge problem. People just, in mostly in an established neighborhood, they see boundary walls and fences.
They
and
think that is accurate.
They just assume that,
Yeah.
that they've been put on the property line and it's correct.
Yep.
And then somebody moves in and they want to remodel and they want to make the property, take the house as
Exactly.
close to the property line as they can. They want to expand
Yes.
it. And now all of a sudden they need that 2 feet because they
Right.
need the side yard setback.
Yep.
And all of a sudden, they're tearing down the wall, and you're going, wait a minute, that was my wall.
Wait a minute.
And they're moving it 2 feet closer to your house, and
Exactly.
that's when the litigation starts.
Yep.
So
Good times.
I always recommend. I always recommend getting a survey. When you're buying a piece of property.
Yeah.
Get a survey if you can.
It certainly doesn't hurt. It's just more information, so you know
information that you
exactly
have.
what you're getting.
Exactly.
So we're almost out of time. Just wanted to check in with you. So overall, your wealth, obviously a wealth of knowledge and information. What would you say to our viewers and our listeners? What would you say would be the best advice that you could give, just for, generally speaking, for hiring a real estate attorney?
Well, obviously hire me. But
Absolutely.
But-
Greg Kaufman.
there you go. But I think that usually, and most, I find that most good real estate agents and brokers will probably have a good referral. I find referrals.
Absolutely.
Referrals are, to me, the best source of finding good people.
Yep.
Because if you're dealing with somebody good, they usually know other good people to work with.
Absolutely.
Usually local bar associations have referral services as well. But I like knowing somebody that I trust that can then refer me to someone that they trust.
I do too. I would say probably 90% of my business is referrals. So that to me says something. Usually when I get a client, they're usually clients for life, which I love. It means that I travel a little more over Los Angeles than more people, but that's okay. It's kind of like I like that as well. So I build exactly like a team around me of people that at any moment, I can refer you to somebody, to a client that needs a real estate attorney, a great mortgage broker. That's all of that stuff is really, really important to keep in your little chest, your little trove chest of referrals. Absolutely. Well, thank you so much for coming to the show today, Greg.
No, it's been my
and,
pleasure.
in case anybody would like to know how to get in touch with Greg Kaufman, how would they get in touch with you?
Well, they can give us a call. Our phone number is 310-553-1400, or send me an email at Greg, Greg, at rndlaw.com. This is randklaw.com.
Fantastic. That was great. So now you have a really good real estate attorney, at least locally based in California. Are you certified anywhere else, or is it just California?
Nope, we're only licensed
Yep,
in California.
that's what you got to have, one bar. Some people are very over ambitious and get licensed in a couple of states, but I wouldn't want to do that. But thank you for coming to the show
It's
today.
been my pleasure. Thank you for having me.
So thank you for coming today and listening and taking time out of your day to listen to Real Estate of Mind, where, we want to keep it real simple with real investments and real answers. And I think today what I started doing is I really like the real estate tip of the day, and the tip of the Real Estate of Mind tip of the day, I think in your case was basically, hire an attorney before the problem gets big. Have a little foresight to think if this is out of your wheelhouse again, and there's a lot of legalese involved with it, hire a real estate attorney so that you can sleep easier at night, protect yourself, and know what you're getting into. So thank you again for coming in for Real Estate of Mind. This is Jamie Austin. See you next week.